Guys, welcome to another edition of Hottie. Go do what you gotta do. Good morning, guys.
Good morning, Mr. H.
Rise and shine. We work as teams here at the Hottie Law Firm. We're all socially distanced apart in this room. Everyone's masking up. We have sanitizers, and in fact, we have Hottie sanitizers. Guys, if y'all want any Hottie goodies, please, sanitizers. We have Hottie sunglasses. We have Hottie Girl Scout cookies. We have Hottie masks, Hottie hats. You just got to send an email to info@thehottielawfirm.com and let us know what you like, or just say you want a package deal and we'll send you some swag. Guys, today I have mediation at 9:30 on a case where we have multiple insurance policies involved, third-party tortfeasor policies and first-party UM policies. And through the years, I've always asked, and I even asked a defense lawyer named Barbara Hackenberg, who works for Germer, what happens when a third party, let's say Geico, insurance company, violates the Stowers demand. And if you want to learn more about Stowers, we should have a forum up soon, but our law firm graciously set the standard with one of the most powerful Stowers demands on November 12th, 2020 out of Montgomery County, where Geico refused to pay us the 30 policy, refused to pay us 40, refused to pay us the verdict of 124 with interest 135,000, and we took him to trial and got a verdict in excess of $700,000. Now, we might not get paid that verdict, but that verdict that came out of Montgomery County, and thank you to Montgomery County for not letting Geico step in and smear their garbage around your county and to trick you to change a 100-year-old law, Stowers Doctrine. A very powerful law that says, in the event that a plaintiff's lawyer sends a demand to a third party and it's within the policy limits, liability is reasonably clear. Remember, reasonably more likely than not. One thing we set was you don't have to have 100% of the damages. You don't have to have liability at 100%. More likely than not standard. And we won that argument. So our case where Geico paid us the policy in 71 days, and now we're waiting to get paid for over $150,000, we refused to accept it because it was untimely. Because these laws are there to govern the insurance companies, and if you let them slip up once, they'll do it again, do it again, do it again, do it again. And that's why we set the standard for being the only law firm in the world to assist the Texas Department of Insurance in sanctioning Geico for $5.2 million last year. And then they had to change their entire corporate practice by October 12th. I guess Warren Buffett didn't like that, and he sent his lawyers against us, and that's why we popped them on November 12th, 2020 with the Stowers trial. Following our Stowers trial, for the first time that I know of, the United States Court of Appeals in the Fifth Circuit, which the Fifth Circuit, I believe, is Texas, Louisiana, and Alabama, if I'm not mistaken. I think there's possibly 14 Court of Appeals. I might be off on that one, but I don't think so. I think there's 14. The fifth one, Fifth Circuit, that governs our state, Texas, on the federal side, issued an opinion on a case that started in the Honorable 127th District of Houston, Harris County. Honorable Judge Sandel. What a blessing that a case in his court had such a powerful verdict that the insurance companies, Chubb, Ace American, American Guarantee, started fighting each other, saying the $10 million should pay the verdict once we pay our $2 million, because there was a $2 million policy with a $10 million umbrella. And these are people on the same side, guys, on the third-party tortfeasor side. The Fifth Circuit Court of Appeals analyzed two of the demands, one of which was the 24-hour demand post-trial, less than 24. This opinion, the veracity, unbelievable how this Fifth Circuit opinion that was issued on December 21st, 2020, and you can find it online under Fifth Circuit opinion, cause number 1920779. How it changed the concept of Stowers, and I guess by the grace of God, followed our verdict out of Montgomery County. These two verdicts, one just as powerful, one even more powerful than the other when it comes to protecting the rights and benefits of anyone hurt or harmed in the state of Texas. Every plaintiff's lawyer out there benefits from these two powerful verdicts, because when the insurance company comes and slips up and says your case just isn't worth that much because we roundtabled it by the trash can, You say, no, I beg to differ. The verdict that the Haughty law firm had out of Montgomery County says the opposite. It says you're in trouble. So today's mediation, I have cases where you have Geico third party, Geico first party, and that's a whole different story on how we had adjusters fired for tampering with that. But these two companies, although the same, cannot cross this invincible wall, like it's like a firewall. They can't share, collude, conspire. They've seen what happens, right? Then you have cases like Geico third party with State Farm first party. And I've asked individuals like Barbara Hackenberg with Germer, I said, hey, when the third party adjuster messes up and violates the Stowers Doctrine, and I asked her this April of 19, way before all this, what happens? Does my client's uninsured, because everyone out there, all you say is don't touch my insurance because my rates will go up, right?
Yes, sir.
Right?
Yes, sir.
Isn't that what most of the people, so why should my client go and use his uninsured motorist coverage that he's paying for when the adjuster said, well, you know what, screw Haughty and his client. They got some umbrella. They have a trampoline. There's a parachute there. Well, guess what the Fifth Circuit opinion did? They pulled out an AK-47 and shot holes in that parachute. They said exactly what I said for years. My client, not only did they say what I was saying, but on the same side, because Chubb, the $2 million Chubb violated the Stowers Doctrine, Chubb had to take the whole entire, I don't even know, $10 million, $12 million verdict, from $40 million right down to $12 million verdict. Chubb has to pay all of that because their adjusters and attorneys, well, we just don't have it evaluated. Well, we ran out of authority. Well, you know what? All of a sudden, I have no authority. Your adjuster ran out of authority? Well, how can I help them find some more? Who's giving them this authority, right? And that's what happened here with Chubb. Chubb rolled the dice and lost millions. And that money doesn't come from the pot that has the policies and the premiums. It doesn't come from the reserve. That comes from the bottom end. That comes from the shareholders of Chubb. That's your money. Shareholders of State Farm, Geico, everyone buying into these stocks, holding on tight. Well, the more money they're losing and dumping to come and prove a point in the state of Texas, and I say Texas because really it's only in Texas, because Texas is a little conservative when it comes to injury type cases, unlike every other state. And don't forget, 97% of these insurance companies are from states other than Texas. 97, think of one. Who's from Texas, guys? Texas Farm Bureau? From Richmond Rosenberg? What a blessing. You should all go buy insurance from Texas Farm Bureau because they're from Texas. They're from Richmond Rosenberg. It's our turf right here. Don't go buying from State Farm and Geico, putting up all these bills. But you definitely buy from Geico because they're going to pay us more than anyone out there. So do buy it. But support Texas Farm Bureau. Not all these insurance companies coming out there and Chubb. Unbelievable. So this brings us back to today's mediation. 50+ thousand in damages. Geico told me have a nice day. Refused to settle within their $30,000 policy. And now I'm supposed to go in there with two lawyers, one of which, unfortunately, I do apologize, sued for breaching a contract. And the other one, Mr. Greg Howard, we put him on the stand on our Stowers case. And he talked about how Germer is like a poo-poo platter. And, you know, that's a whole different discussion about saying poo-poo in court. Yeah, I called him out of my closing. I said my 3-year-old says poo-poo every day. And I tell him, don't say poo-poo. Say something like sunshine. Right?
Yes, sir.
All day, guys. So now I'm supposed to go in there and listen to them tell me something about how this Fifth Circuit opinion that came out on December 21st is not the law, and that my client's carrier should take the hit for the Geico adjuster saying this case just isn't, we don't have any more authority. And we'll see what happens. The case might settle, it might not, but I don't think my client's State Farm carrier should pay a penny, and I do think Geico should take a big hit. Guys, last week's mediation, I challenged myself to hit 300. We got very close. I'm not sure how close, but we still walked away because mediation is an avenue of compromise. And if both sides can't meet, right, then you walk away. There's no pressure. You still have trial left, guys. And look at all the amazing verdicts coming out of Harris County. Never be afraid to take your clients all the way to trial. That's why I do what I got to do, because all they tried to do was scare me to go to court. My dad was my best motivator. Go to trial. Of course you can do it. Dad, I've never been. Don't worry, go. God bless, right? So let's go see if we can somehow educate individuals today on the Fifth Circuit opinion. Guys, if you have any questions, please email us anytime at info@thehottylawfirm.com. We're always here to rock and roll with you. Thank you, my friends. Yeah.
So it is